Okay, so basically, there's a lot of material within the transcripts which is pretty problematic for Gorton, and like it's taking me ages to finish the thing because what I've done is, so I've first, to scope the work, I've not very quickly, but I've gone through it in a more broad stroke way and like divvied up. These are the ones that have not been done. So the ones that you saw, they have been done, but I will still refine them further, as in the headings. But the ones that are left, there are two which are extremely consequential. There's the 5th of December and the 14th of December. And basically, it's very fucking dense, and there's a lot of material there, and also subtext there. And okay, so let me read this to you. Okay, this is one of the headings from the 5th of December, because it's just impossible to explain in the abstract. So Gorton J emphasizes that His Honor, open quotes, just wants to get this right, close quotes, comma, open quotes, get it clear, close quotes, and open quotes, write it down, close quotes, that the Kuksal parties have, open quotes, acknowledged, close quotes, that, open quotes, there's nothing, close quotes, in the open quotes material that comes through the prosecutors to Mr. Kuksal as part of their disclosure obligations in criminal offences, close quotes, open quotes, that relates to misbehavior by Gorton J, close quotes. His Honor stresses that, open quotes, he's interested by, close quotes, the Kuksal party's account of the LSB's covert correspondence with the courts to improperly influence judicial officers presiding over their proceedings and seek private determinations against the Kuksal parties from them. His Honor repeatedly inquires if the evidence of the misconduct that they've discovered includes, open quotes, something that's come to or from Gorton J, close quotes, or, open quotes, anything to suggest that the LSB has contacted Gorton J, close quotes, open quotes, secretly had a discussion or conversation with Gorton J, close quotes, open quotes, tried to improperly influence Gorton J, close quotes, or, open quotes, come to Gorton J and got private advice or orders or powers or something like that, close quotes. Gorton J continues to stay silent about whether His Honor has engaged in the conduct he described with the LSB. So basically, he asked me 5 times, repeatedly. And I mean,
He was very specific about what he was
exactly. He said, you know, whether, I mean, I didn't even go into that much specifics. And that's one thing, okay? The second thing is that this is the worst aspect of it. So what I was doing that day was basically exploiting the position that I had. I knew that he was never going to give us the leave for the Harman undertaking, but I was using the opportunity to basically openly accuse the LSB of the things that our evidence demonstrates that they've done, because he was never going to let me make those accusations. And the pretext was that if he knew about the truth of that, he could not have judged things the way he did, and he's bringing the administration of justice into disrepute by being careless in rejecting our evidence, because it prevents him from actually seeing this. So then the only way he could actually determine that was by letting me show him what I was saying he was he was being careless in not actually seeing for himself. Do you understand?
Yeah.
That day I had a bet with you. You said he would not let us play the videos in court, and I told you he would. Anyway, so because now this is what happened next. Now, Norton understood that I was exploiting the opportunity, so she says, let me say this, Your Honor. She says, well, Your Honor, I must say, I had only no, sorry, it's before that. I'd begin by saying that certainly outrageous and scandalous allegations have been made. Gorton immediately shuts her up. He says, okay, I don't need to hear that. I don't need to hear that. Norton, thank you. I have instructions to release the documents to the court so that Your Honor can see the documents. Gorton, I don't want to spend 3 days looking through the documents trying to find something. Norton, it's only 16 pages of correspondence between a representative of the board and Victoria Police. I reviewed it last night. Gorton, is this the material that Mr. Kuksal is talking about? 1 second. The Supreme Court just sent us an email, and basically they've listed the LSB's summary and Victoria's summary dismissal applications. This is like the quickest they've ever listed anything.
Yeah.
You know, because the hearing was on the 17th, and within 2 days they've listed the matter for the 26th of August. But basically, we have liberty to apply, so we can apply for subpoenas and everything, and also interstate judge. But yeah, it may not be a bad thing. I think the court wants to move the matters now, because a lot of stuff is happening, and I'm Anyway, it's a good thing that they're moving it quickly. Gorton is, basically practically dead from his shame. Anyway, so she says it's 16 pages of correspondence, and then this gist of it is this. Gorton says to me, is this the correspondence you want? Now, he is really fucking nervous. And he basically does not want to receive the material from the LSB. So he asks me if this is all the evidence that I would want for him to see, and I say no, but this is a lot of it. There's a few pages more that I have, but it's okay. He can just have a look at that. And he says, no, I'm not going to have a look at that. I don't want to have a look at a lot of voluminous material. And I'm like, I only want, sorry?
14 pages.
16, she's saying. And,
Yeah, 16.
yeah, and I'm like, it's not voluminous. I wanted to put in less than 20 pages. And he's like, 20. I'm like, yeah, just 20, if you allow us to. So he says, can I just say this? There's nothing you've said so far that inclines me to give you a release from the Harman undertaking. To put the so first he tried to say, there'll be thousands and thousands of pages. So when Norton offered, he says, I'm not going to spend the next 3 days going through thousands of pages. And she said, it's only 16 pages. And then he says, is this all? I'm like, no, there may be 20. And then he says, no, I'm not going to give you a release because you should get it from the court where you got the documents. I'm like, you don't need to give me the release anymore. They're giving you the documents. And just, let's rely on that. And then this is what he says, literally. Okay? I don't know what damage I'm going to be causing to someone if I do that.
What do you mean by that?
I don't know. Like,
That's a point.
I mean, it's self-evident. So I'm like, you have the authority to access the documents. He says, I might have the power in theory, but I'm very reluctant to do it. I don't know what damage I'm going to be causing to someone else if I do that. And by the way, this is correspondence between Victorian Legal Services Board and Victoria Police about how they should basically go after me. So we're not talking about, intelligence secrets. Like there's no public interest consideration here, and the documents have already been released to me. So they will be in the public domain anyway. So he's not actually releasing anything. But he says, I don't know what, and he said that after I basically cornered him from every angle. So he says that's the first point. The second point is that and I'm like, I interject him and I say, well, you don't need to even talk about why you don't want to release it from the Harman undertaking. They've already offered. You can't even fucking reject it because they want to put something in evidence, and you have no basis to not accept it in evidence. First, I mean, he has to take it, then say it's irrelevant or something. By the way, he can't even, it's for the other party to raise objection.
Yes.
So then I'm like, they want to help us. What's your problem? So he says, well, and then he mocks me. He says, if they want to help us make this argument, maybe I'll accept it then. And then he turns to her and literally he says, so what are you saying? You want to help Mr. Kuksal by giving them these documents? So then he will come back and based on that, he will seek more documents. And literally, this is what he says. So, are you, so I'm going to read it now, literally. I was paraphrasing partly. So, what are you proposing? That I start looking at documents? And she says, well, Your Honor, I was seeking, he says, I start looking at documents and with a view to Mr. Kuksal, you're relying on those documents in support of his application. So what he's saying is that you want to introduce these documents now, and the way you want to introduce these documents, you being the LSP, is by relying on Mr. Kuksal's application to introduce these documents into the proceeding. He's basically saying you have no basis to introduce these documents into the proceeding because the only way you could do that is by relying on Mr. Cooksal's application. So what are you saying? You're relying on his application to introduce these documents? And to what end? So he can get more documents to ultimately support his application to say, I should recuse myself, which will presumably have to be heard in some weeks' time when all those documents have been obtained. And then this is what Norton says. She says, I must say, I had only understood that the 16 pages of correspondence were the documents that he was seeking release from the Harman undertaking in respect of. If the release that is sought is broader than that, I can't assess. I should clarify. It's just been brought to my attention. And then she starts backpedaling. And she says, well, we may need to get Victoria Police's permission. And I'm like, no, they wouldn't. And then, she still feels that Gorton is basically misunderstanding. So she clarifies. She says, all we were saying is that we provide these documents to the court, but I don't seek to make matters more complicated, Your Honor. I was seeking to provide those documents to Your Honor if that was possible. They're relatively short, in relative short compass, and in my submission, they will make abundantly clear to Your Honor that the correspondence between the board and Vic Paul had absolutely nothing to do with Your Honor. Do not mention Your Honor's name. Do not hint. So she's basically now clarifying to him that he doesn't have to worry so much because his name is not caught there. Okay?
Yeah, no.
And then this is what he says. Well, so far Mr. Cooksall hasn't said that any of the documents he's seen have mentioned my name at all. Okay? This is after all of that exchange that I talked about, where he literally asked me 6 times in different ways. And she says no. Then Gorton says, he's been quite careful to say all they show is that the VLSB contacted the court. And I say courts, various courts. And he says courts. But you say that, Ms. Norton, but you've looked at it. It seems a small subsection of the sort of documents that Mr. Cooksall's relying on, just going through the affidavit that he's. And then she says, which I haven't had an opportunity to review, and I should say we still don't have the exhibits for that affidavit either. I'm like, there are no exhibits for that because we were seeking release for the fucking exhibits. And she says sorry for the previous affidavit. Then he says, oh, yesterday's affidavit, 6 or 7 other affidavits are exhibited to it, blah, blah, blah. And so what are you saying, Ms. Norton? You want this whole thing to be adjourned for you to look through the thousands of pages of exhibits to come back to a recusal application? She says, no, absolutely not, Your Honor, absolutely not. I was seeking to assist the court. It appears that I haven't. I will just resume my seat. Do you understand?
Yeah.
He's mocking her.
Trying to protect his own backside by finding out by one newspaper saying, finding out from you, if you finding out if you had any impact on any of what the documents were saying, then he basically was stopped there from putting in.
But I mean, the way in which he was so.
He's going to would have been a simple exercise with 16 pages.
No, Peter, this has gone way beyond the. I mean, this is going to be all over everywhere now. People are going to go crazy with this thing. Because what I've done is, and so I then used this to play the videos. Because he was so fucking, shaken up by the whole thing. And I mean, the judgment that he wrote, this is what it says. I can't believe that I could work him this much. This is what his judgment says. Mr. Kuksal sought release from the implied undertaking immediately so that he could rely on the documents in his recusal application. Mr. Kuksal was, of course, limited in what he could say about the documents, blah, blah, blah. The documents would be relied upon, he said, to establish that the board had engaged in improper behavior and was prepared to communicate directly with courts and judicial officers. So, apparently in the judgment he thinks that's improper behavior. He proposed then to submit that this added to the perception of bias or possible bias. He candidly, and to his credit, acknowledged that he would not rely on the documents in order to establish that the board had been involved in any inappropriate communications with me or my chambers, or that I had behaved in an inappropriate manner. Okay, makes no mention of the fact that the LSB had offered to produce the documents. No fucking mention in the judgment. I mean, forget about what his interpretation of it was. It was a significant event, and I had relied on it as a specific ground for his recusal or disqualification because he was, scandalously obstructing, in effect, the disclosure of documents by them. I mean, he harangued her, like he humiliated her. He says, what's the basis on which you're providing these documents to me? Like you're relying on his application to provide these documents to me? And she's like, I was only trying to fucking help you, because it's only 16 pages, and if you read them, her point was that if you don't read them, Mr. Kuksal will spend hours, describing what those documents can establish in court and, basically be abusive toward her client. And instead, he can just read the documents and end the matter conclusively very quickly, which is a reasonable position, by the way. So he says no, and she then clarifies to him that his name is not in the documents. I mean, this is how pathetic it is. And then he still doesn't, because he knows that I will then use that to get more, to ultimately get the recusal application. And I haven't even gotten to the worst part yet. So what happened is, I kept telling him that day what he was here. He was hearing 3 applications that day. An application for his recusal, the LSB's application for the dismissal, and our application to amend the originating motion. And I said that we would need the documents anyway to amend the originating motion, because otherwise they're going to say we have no evidence to make the allegations that we're making. Now, we were going to adopt the summons into the originating motion, and he basically did not want to discuss any of that, because my point was that, okay, if he doesn't give me release right now, he just needs to adjourn the matter for 2 weeks, because the documents will be automatically in the public domain in 2 weeks anyway, because there was a hearing scheduled. So that is what would have naturally happened. And now he was stuck because I was going to take the whole day for the recusal. He didn't want to give me an adjournment anyway, but in effect he would have had to give me an adjournment. So he basically said that, because I have a recusal application right now, I can't even think about anything else. So I'm not thinking about the adjournment of the originating motion or any of that. Okay?
Yep.
And I'm like, but you know, we want to start filing the material for whenever whoever thinks about it. And he says, well, you know, you had time to file, and I said we have filed. I just want to talk about what we filed. So we were going to rely on the summons to say that this is what needs to be adopted. So he didn't let us. He didn't want to hear any of that day. He said he's just going to hear the recusal and then get back. When he got back, he dismissed our summons to amend the originating motion because we hadn't provided any clarity for what the amendment will be. 4 times I fucking brought this up during the hearing, that what's going to happen to our application to amend the originating motion that was also to be heard today. He said, well, you know, I can't even think about it right now. And I'm like, so you're adjourning it? Well, he says that's the practicality of it. And he dismissed it because we didn't prosecute it.
Well, that's ridiculous. Even he's allowed to move the matter forward.
So you know what? I've got ChatGPT to create a model about him, and this is what it says. And it's really funny because one second, let me just bring up the. This is groundbreaking stuff, Peter. Like, we will soon be. This will change the system forever with the. So. Okay, so firstly, it says a judge in the shadows, concealed. This is the profile of Gorton. 1, he's a judge in the shadows, concealed ex parte dealings with the regulator. So it says direct admission of contact. So it's referring to the quotes from the day. So during the hearing of the 5th of December, he also ruled that even if they had communicated with him, he doesn't think that that was a problem. Okay, then so the ChatGPT considers that to be an admission that he had, you know, on the balance of probabilities with everything else put together. So then it says repeated disclosure demands. It says that we've, you know, repeatedly asked for disclosure of documents, and he's always obstructed it. And then inference. Under Christius v. Christius, this is a High Court authority from 4 years ago, very prominent. The very fact of undisclosed private communications with a litigant's adversary is sufficient for disqualification. The silence in the face of focused questions supports an inference that the communications exist and are prejudicial. So this is one aspect of his profile, which is a judge in the shadows. The second aspect is procedural sabotage, blocking evidence that would expose the contact. Then it says subpoena obstruction. He's been, you know, he dismissed our subpoenas or refused to issue them. Then scheduled a mention solely to debate whether the subpoena was an abuse of process. So what ChatGPT has identified that as exceptional behavior, that, you know, he preemptively listed a hearing to say that it was an abuse of process. He can't actually, anyway. Cross-examination shutdowns. when Ms. Xu tried to question LSB investigator on 20th to 21st of August about the source of the original complaint, Gorton cut her off and physically removed Mr. Kuksal from the court. Then he raised Section 13 Evidence Act objections. Inference: a decision maker who knows disqualifying evidence exists has a personal motive to prevent that material entering the record. The suppression of subpoenas in cross-examination is explicable as self-protection, not neutral case management. And then that's the second aspect of the profile. The third aspect is misrepresenting the record to sanitize misconduct. Judgment distortions. The 26 January 24 cost ruling recast an unfiled protective costs application as one that had been argued and lost, clearing the way for punitive indemnity costs. Do you understand? We never got an opportunity to be heard on protective costs. And the irony is that after dismissing our application, before McAuliffe, he was all like, there's a public interest in these people going after your client, but only to the extent that, I cannot get caught. So he basically removed everything that could reveal. That's why he didn't want the amendment to the originating motion. So he has no problem with us seeking declarations that their appointments were wrong.
Yes, correct.
And the number of times he's emphasized the public interest in that. In fact, at one point he was like, even if they didn't have a private interest, there's clearly a public interest, so they should be allowed to do it. So that's the sole criteria for a protective cost order. Yeah, that it's a public interest litigation.
Yeah.
And I mean, we don't even have to fucking file an application. He knows what the case is. Do you know what I'm saying?
Yeah, he's speed with.
He had seen the videos by then.
Yeah.
And I've never made any submissions after that date anyway, because he always kept kicking me out. And then misrepresenting the record to sanitize the thing, I've covered. Then registry manipulation and ambush listings. And then it says registry gatekeeping. So it's basically blaming him for the registry blocking the filing of the originating motion because you don't have a practicing certificate, because it thinks that he was involved from the start, but he wasn't. So we take that aside. But administrative reasons on request. When plaintiffs began threatening judicial review of listing refusals, Gorton J started issuing written reasons preemptively, a departure from normal registry practice witnessed by Mr. Kuksal in recorded calls. So I gave LSB ChatGPT all of the data, and it has picked up these things. Then inference, the simultaneous appearance of registry obstruction and Gorton's anticipatory defensive memoranda is best explained by off-record coordination. This is what I was telling you about. And, the program has also come to the same conclusion. By off-record coordination designed to keep sensitive material out of open court. Retaliatory costs strategy, indemnity costs orders. In February 2024, the judge granted the LSB indemnity costs for objections that were themselves based on complaints about his conduct, even while holding that similar complaints in a sister proceeding should attract no costs. So,
It's pretty damning, the summary.
I know. I mean, it's damning because of the way I've structured the cases all this while. We don't understand. I always knew that this is where it was going. I mean, all ChatGPT does is processes information and pulls out the relevant part, and it doesn't even do as thorough a job as I do, obviously, because of the time and thing that I spend. Anyway, so the fact is that on the 26th of August, when I accused him of being a scoundrel, okay, let me read you this. This is also pretty fascinating. So I list all the cases that he's violating, and I say, he hasn't explained how he's not following these high court authorities, and all of them say that what he's doing brings the administration of justice into disrepute. So he says, Mr. Kuksal, what do you want me to do? You're just referring to all these things. And I'm like, to consider them. He says, shall we adjourn today? And I said, it's scandalous, Your Honor. You're not concerned about the allegations that have been made about you. He says, when do you want me? And I'm like, all you're concerned about is basically implementing an agenda that you have. He says, Mr. Kuksal, I'll tell you what. You're mentioning all of these cases. You're expecting me to go and look at them. And then I tell him, I said, I'm expecting you to charge me with contempt. The things that I've said, if they're repeated in public, if the public knows that this was said, which it will, and he tries to change the subject immediately. He says, but why didn't you, I say again, I'm like, no, Your Honor, charge me with contempt. He says, if you'd given me some notice. I'm like, if I'm making these allegations improperly, you charge me with contempt. All right. All I was raising, he's like, calm down. All I was saying is that you should have given me some advance notice. I'm like, and I'm saying it's scandalous, it's dishonorable. He says, all I was doing was raising a sense of dissatisfaction that you just throw up all these cases in oral argument. And then I said, Your Honor, if you do not charge me with contempt, it will bring the administration of justice into disrepute after I've said the things that I've said. I think it would be a precedent of its own sort, which would be deserving of exceptional publicity. And he says, so what do you want me to do? Go and read all these cases? Literally, like he's just desperately trying to change the subject. And, you could not fucking believe, what's his name? McAuliffe was about to crack his fucking, spinal cord. Because, he tried to keep his head down, and then I would say something completely fucking outrageous. And then immediately he would look up with a jerk action. Because you'd be like, how can Gorton take that? And then I would think the same thing, and Gorton basically would just keep looking down and, acting like nothing's happening. And I'm like, if I'm saying, charge me with contempt if I'm making these allegations improperly. He says, but I'm talking about all these authorities you're referring to. I'm like, that's not the point, Your Honor. You're missing the point. You are bringing the administration of justice into disrepute. This court does not have the resources to check that everybody will comply with what is required. He says, yes. There is a good faith basis upon which people submit to the jurisdiction. What you're doing is undermining that. And then I say, this is a scourge on all your peers. And so, yeah, that's what happened that day. And then, there can be no doubt that he desperately wanted to stay in the matter to dismiss those parts of the application. At any cost, he wanted to be there. No, there's no other inference. And I haven't even, so I'm going back to the profile now, the ChatGPT one. So stay request, retaliatory cost strategy. Okay.
Trying to read from ChatGPT.
Yes, retaliatory cost strategy. In February 2024, the judge granted the LSB indemnity costs for objections that were there. So the reason I read that to you is because that application was obviously made much after February 2024. You know, so all the applications were abuse of process because of how many times I've made them. Yeah?
Mm-hmm.
So the August one was one more, at least. Well, it was actually many more because many applications have been made by then. But at the end of that judgment, he specifically noted that he does not think that there is any need to determine whether or not that recusal application was an abuse of process. Do you know why?
Why?
Because if I had called him a scoundrel and a person so corrupt that you couldn't possibly bribe him into being more corrupt, and all of that as part of an abuser process, then I automatically get charged with contempt.
Sorry, if he, I don't know why you automatically get charged.
Because that's the definition of contempt, that you are abuse.
I think what you're saying. I see what you're saying. Saying that if you
If I didn't have a proper basis to say that,
in place dereliction of what dysfunction if you did.
No. I mean, I think even if he didn't, someone else would have been obliged to charge me after that, because anybody who's responsible for maintaining the court's dignity, if it is known that I was being abusive in court as an abuse of the court process.
Yeah, I understand what you're saying. I think I follow.
So he deliberately.
Hid it or kept it quiet, or when you want to burn it, didn't raise it.
No. He deliberately ruled that he's not saying that that application was an abuse of court process. I mean, he didn't even have to say it. He could have just not mentioned it at all. But he specifically said that that application, he's not ruling was an abuse of court process.
Yeah, I follow what you're saying.
Whereas every other application, recusal application, after the first one, which was made, I don't know, in August or September 2023, after that, every recusal application has been an abusive process, except for the one where I basically called him a scoundrel. Well, I literally called him a scoundrel and all of this stuff. So, and then this is where it goes. So it says, inference, costs have been wielded punitively to chill the very speech that could expose chamber-level impropriety, evidencing retaliatory motive, and therefore actual rather than apprehended bias. And then it says the logical conclusion of all of this, or the systemic patterns. So it says, when the strands are read together, so strands is actually a technical term, it's from the authorities that define consciousness of guilt. When the strands are read together, the only coherent explanation is that private LSB chambers contact occurred, admissions plus unanswered FOI plus transcript references demonstrate that. Exposure of that contact would prove Gorton J's disqualification and potential liability. Every contested procedural ruling, that is refusal of subpoenas, ejections from court, suppression of affidavits, selective indemnity costs, judgment distortions, tracks the judge's rational interest in concealing the contact and punishing the party attempting to uncover it. That conjunctive chain satisfies the High Court test for actual bias. A decision maker whose own interests lie on the substantive battlefield cannot be, in quotes, independent and impartial. And ironically, the authority that ChatGPT quotes for this is Gorton's favorite, Ebner versus official trustee, and it even cites the paragraphs. So what ChatGPT says is immediate implications, judicial commission referral for actual bias investigation, automatic setting aside of all orders made after July 2022 in the affected proceedings, system level reform, mandatory disclosure logs for chamber correspondence, public registry dashboard, and blah blah blah. Justice Gorton's conduct, now documented in his own words and in his handling of procedural levers, cannot be rationalized as error. It is a pattern of calculated judicial sabotage that subverts the rule of law and demands urgent institutional response. This is what it's saying. And I mean, it's a very conservative fucking thing. Like, for almost a year, it kept telling me that, maybe Gorton has something, a proper basis to do this or that. But now it's basically, and then this is what it says, yeah? Psychological profile and motivational analysis for Gorton. I asked it to construct that. And it says, cognitive style, defensive formalism. Gorton exhibits a heavy reliance on technical rules and formal procedures in contexts where equitable and justice-driven reasoning would call for transparency. This suggests a judge who finds psychological safety in the form of law rather than its substance, a hallmark of defensive cognition under institutional pressure. Do you know what the institutional pressure is?
Yeah.
That's right. That was the whole fucking irony in all of this. You know, like, IBAC is on his fucking side. You know, the Legal Services Board is on his side. The whole fucking system is on his side, and then authority preservation bias, aversion to accountability, controlled retaliation. Summary of inferences. Gorton J. likely had private contact with the LSB. Judicial decisions were tailored to suppress investigation. Orders were retaliatory, not merely procedural. A broader scheme of systematic protection is in play. So, I know. I mean, there's no doubt that he's going to get fucked for this.
I mean, ChatGPT too, isn't it? Isn't it one of the bases of it?
It doesn't matter, Peter. Listen, it's qualifying everything that it's saying anyway.
Yeah, no. I'm just saying, but isn't the basis, one of the bases of it is that, you know, if you put something in it 12 months ago, it's more likely to give you a better response in the present. Because, I mean, isn't it meant to be continually adding to its knowledge or improving?
Yeah, so it's learning from all the material that I'm providing it. But
it also learns from other material too, doesn't it? Like it's,
yeah, but the knowledge that it would have gained in the last, well, it's not been 12 months since we've been doing this, but let's say 6-7 months would be negligible compared with. So it already knew a lot about the legal cases. It wouldn't have learned anything substantially new about legal cases or about Gorton from the public domain. Yeah, and also the law hasn't changed. Sorry?
Oh, no, I'm talking about process or procedure or...
No, because the most groundbreaking authority, the newest one is QYFM, and that's 2022. So that's the most radical authority that came out recently, which is totally in our favor. And basically what it says is that, you know, judges can't use it as a fucking, you know, mindless and senseless formula that reasonable observer is not going to suspect something. It's basically a tool to prevent injustice in reality, and what they're supposed to do is prevent any circumstance where people will actually have a cause for concern. So, I mean, 1,000 people have signed our petition by now. It's 800 something. So it's not like everybody who hears it says that Gorton is a fucker. I've not found one person to come in Gorton's defense after hearing the thing. I mean, he knows that what he's doing is anyway. So it's all of this and everything put together, and it's also stuff like, so I told you on the 2nd of December, Hogan wanted to make a complaint about me because 2 days earlier his his instructor had written to us and said that we haven't filed any evidence to support Rapke's the allegations that we're making against Rapke and all the other people. And then I wrote back and I said, listen, it's one thing for a judge to be corrupt and for a government body to be corrupt, but like law firms and lawyers are, I mean, I'm paraphrasing, but basically what I told him was that he was an easier target and I will go after him for misconduct if he continues to break the law thinking that he's as immune as they are. And then I said, also start reading things quickly before Gorton actually sets everything on fire to save his ass. And then I said, I'm speaking figuratively. So Hogan said to Gorton that there was an improper threat in that communication. And Gorton was like, no, like I've gone through the correspondence, I've never seen anything. He says, I don't know, maybe I've missed it, but he says, I don't think so. He says, Mr. Kuksal, uses very strong words, but I've never detected an improper threat. I mean, the only, and I'm putting this in the submissions that I'm quoting that, I'm putting the quote from Gorton and then I'm quoting what I said in the email. And the only way it wasn't an improper threat is if Gorton is actually, corrupt. Do you know what I'm saying?
Yeah, no, I don't. I forget.
Like, and then Hogan is like, maybe I'm mistaken, I'm not going to press it again, but,
Okay, I understand what you're saying. So what's the basis of him saying that? What's his rationale of coming up with that?
Because basically it's contempt of court. If I get charged with contempt of court, Gorton is fucked, because the first thing that the judge will have to do is give me disclosure. It's a criminal charge. So, as I was saying, Gorton is guarding my reputation, at least in one respect, with his life.
Yes. Yeah, I follow now why he's saying it.
I mean, he immediately shut them down. He was like, no, Mr. Kuksal, like he couldn't. He's like, he just, maybe uses some very strong language, but, abusive and threatening, not the Mr. Kuksal that I know. So, and this was after he had kicked me out of the hearing.
Yeah.
So, and that's, but the point that I made to him was that the only times that he was perfectly happy for me to be in the hearing and call him a scoundrel and all of that. The only times that he kicked me out was when I wanted to cross-examine Anstey or raise objection about McGregor. And then the final time was when I wanted to ask him about his communication with Quigley.
Yes.
Otherwise, he was perfectly happy for me to, do whatever.
Yeah, right. Yeah.
Never had a problem with that. So he's basically completely fucked, and I mean, the way in which I ran the thing, I only started accusing him so boldly after it was clear that he had communicated. And it was literally the ultimate test, because what I was doing was clear. I mean, contempt doesn't even fucking begin to, like, the only way I could say something worse, arguably, is if I started calling him a pedophile or rapist in court.
Yeah, no, I know that you were very savage on him.
I mean, I literally thought about what's the worst thing I can say. And the worst thing I know you can say to a judge is that they're taking a bribe, which you cannot say without having any proof, is the law. So I said the next best thing, which is that, it doesn't even matter if he was taking a bribe, because he couldn't disgrace himself further. So, and then he did nothing to that. And by the way, can I tell you, Downs is also effectively crooked. She's not. So, firstly, the federal court people, I think the Chief Justice, she gave it to someone in Queensland because of the criteria that applies. And normally it's the Chief Justice that makes these decisions automatically where there's a concern. So she gave it to a judge in Brisbane. I think I'm not sure whether she chose this person, or what they've said to me is that the National Allocation Registry did it. But when I was speaking with you about her judgment, I was driving back from the hearing and I briefly looked at it on my phone. Now I've gone through her judgment. So, complete fucking fraud. She has made up shit. So, if I had misread what she had written, because I read it in a cursory way. So she didn't say that she stopped her associate from reading the things because it's a policy. She said that we had sought to send her ex parte material. So material through ex parte correspondence.
Yes.
And that's why she asked her associates not to look at it. And that's bullshit. It wasn't ex parte.
Yeah.
So that's what she said. That was ex parte. The second thing she said is that she asked us for a response to the proposed orders. She asked both parties, and we never responded to her, and they responded to her. Firstly, we responded to her much before they did, and we asked for more time. She has not mentioned that at all. And she said we sent her numerous emails. We sent her 3 emails. 3 emails, literally. And the last 2 were, the third was a continuation of the second, and it was in response to something that the LSB had said.
Yeah.
3 is not numerous anyway. And
Yeah, no, it doesn't. It needs more than 3. I agree with that.
yeah, and it was only the last 2 emails that had the material anyway. The first email simply said, we need more time, and we apologize for not getting back to her by the proposed deadline. And it set out the fact that we were going to file a constitutional notice and this and that. So everybody was on notice. Okay, the other thing is that she started, just like Gorton, she started by painting a picture. She says that this petition was lodged these many months ago. There's not been a hearing still. we asked for 2 judges to recuse themselves, and pursuant to our applications, 2 judges have recused themselves in these proceedings. I mean, complete fucking. We never asked for Mushinsky to recuse himself. We said that we think that he's disqualified, and we want to give him the material because he may have forgotten.
Yes.
And I was very fucking clear about the fact that his own judgment doesn't say that we asked for his recusal. Because recusal is a different thing. What we said is that he's disqualified, and we're confident that if he remembered the details, he would himself accept that. But if he doesn't, then we will raise a recusal application in court. And then he issued a statement. He says that I had heard this matter, blah, blah, blah. Mr. Ansel reminded me that, he was a party, blah, blah, blah.
Yeah.
I obviously have a conflict of interest. I should not be hearing this matter.
Fairly straightforward.
She said that we asked for his recusal. She's painting a fucking picture. And then, here's the other thing, okay? She said that the other side was totally ambushed by the applications that we made. Like, they had no notice of it. And she says to the extent that they said some things about our applications, they were said off the cuff, and they, Now, basically we made 3 applications, we were seeking 3 kinds of orders through the application. Okay? First one was contempt. We had been foreshadowing that, I don't know for how long. In fact, it's in the judgment of Bennett, which he quoted, that we had foreshadowed a contempt application. She's obviously seen all the communication and the submissions that were filed, and they literally, I had set down the grounds for the contempt application. So they could not have been ambushed by that. Okay? The second thing we sought was basically costs for economic loss, because they're engaging in an abusive process. Also, I have foreshadowed at the hearing before Bennett, and then next time as well. She would know that. And it's also in the orders made in this proceeding on the 20th of May. Okay? The third thing I sought was a subpoena. Yeah? And by the way, the cost argument went nowhere, because there would have been no prejudice if she listed our cost application, and nothing would have turned on the cost application anyway. If all the others were not to be heard, then it would not be the distinguishing thing. Now, the third thing we sought was subpoena. By their own admission, the subpoena application had been heard and decided. Well, I say admission, not admission, but claim. So how could they be ambushed by that?
Correct.
She was bullshitting.
Or hadn't done her homework.
No. This was, you don't understand. This was in the reasons. This was not during the hearing. This was her trying to whitewash the LSB's conduct. And another thing, do you know how she said, you shouldn't give me anything that you haven't filed and blah, 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 yeah?
Yeah, definitely. Recall saying that.
Okay, so in her email to us on the 12th of June, this is what she had written. And she's mentioned this in her reasons as well, which is where I picked it up. She said that I'd invited parties to send me proposed orders, and any unfiled affidavit material that they wanted to rely on.
Oh, okay. Okay. So, she's, because she wasn't, she's just done 180.
She's basically, what she's trying to do is, you know, bury her head in the sand because she doesn't want to deal with the allegations that we will make. And there's no way she can rule against us as per the law. She's trying to avoid hearing the allegations, basically. So one thing I noted was that she was perfectly aware of our claims against Gorton. Because not once was she uncomfortable with the content of the constitutional notice. I mean, forget about uncomfortable. She wasn't surprised. She wasn't. It was perfectly normal. And when I explained to her about the subpoena thing, like the subpoena thing, she was very comfortable. I mean, she had no questions about the subpoena. She did say it was improper. We were subpoenaing a judge and saying that, fraud and collusion and all of that. The natural reaction for everybody, if the judge doesn't control themselves, is that, how dare you make allegations about a judge, blah, 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 without proper basis or, so on and so forth. Or at the very least they say, I mean, there's reaction. You know what I'm saying?
Yeah, no, I completely understand what you mean.
Even with Gane, when I made allegations against the police and, various people at the BGSO, he would squirm. Like, I mean, he would listen to everything, but he would squirm.
Yeah, no, I understand what you mean.
So she knew, and she was basically really staying calm and, not making eye contact. And then also, it's a very stupid position that she took, where she says, literally, this is what her reasons say. I wanted them to provide reasons why the interlocutory application should be heard before the creditor's petition. I mean,
Yes.
by fucking definition, interlocutory application has to be heard before the proceeding is over. Do you know what I'm saying?
Yeah, absolutely. That's the standard process.
No, that's the meaning of an interlocutory application.
Yeah, well, that's what I'm saying. It's pre-trial.
Yeah.
No.
Yeah, I mean, the only way you don't hear it is if it lacks any substance.
Yeah.
What she's asking us to help her understand is the concept of an interlocutory application. It's a very stupid argument that she's made, with, and that the other part is she didn't mention that I had suggested that we adjourn the matter.
Okay.
Do you know what I'm saying?
Yeah.
And the other thing was that I had specifically told her when I asked for reasons that she should address why she didn't let me make allegations against their lawyer. She didn't address that at all. She said we're not running a royal commission.
Yeah.
So she's basically crooked, and she's committed fraud. That's like a clear thing, and we're gonna put that on an affidavit, and we'll circulate it to everybody. And what I want to do is actually adduce a copy of your and my conversation right after the hearing, where you're really opposed to it, the recusal application, and I'm pushing it because I want to show, I mean, subject to you being okay with it, but I think you come across on their side anyway, so in that sense there can be nothing wrong. But what I'm going to show is that like we're not doing this because we want to delay the matter, and we need to emphasize that basically for us it's a life and death thing that the matter gets heard quickly. But basically I'm disciplined, and if do you know Gorton in his reasons on the 20th of November ruled that because I hadn't raised a recusal application against him on the first day,
Yes.
I had waived the right to basically make a recusal application based on his previous conduct. He literally ruled that.
Well, that's right.
I mean, technically that's the law, but I had preempted it anyway. On the 3rd of November, when I was making submissions, I had preempted it, and he didn't mention any of that. Nothing of that sort. So you can prove that Gorton is, do you know, like he's hiding very specific things, and there can only be one basis for it. And when you put that with everything else, so the only time he allowed me to play the videos was when I had cornered him like that.
Yeah.
No other time has he ever given us, you know, any opportunity to deduce evidence in the proceeding. Do you know what I'm saying?
Yeah.
So basically, I think we're pretty solid in terms of getting this matter publicized. We write to all the law journals and all the barristers, and I'm sure this is a heated subject right now, and the High Court is hearing a matter exactly on this subject. So it will reach them as well, I'm pretty sure. Like someone will raise it, and the people that are posting about that matter are within our circle. There are people that have reached out to us and, you know, asked us to help them with recusal applications. So I'm pretty confident that this is, and I think it's that's the only way to get these people to do the right thing too, because Justice Kirby, you know who he is?
Yeah. High Court.
Yeah, he's considered to be one of the most iconic judges of all time for human rights matters. He recently published an article about judicial review and so on. And basically, what he said is that there was a time when, you know, the attitude that people are displaying in our cases was acceptable or tolerable or the norm. And he says that time is long gone. Like, he started by saying that in his lengthy career, one of the most prominent scars that he bears is when the High Court reversed his decision. So he was the president of the Court of Appeal of New South Wales at the time, and what he had ruled was that he had given a landmark judgment that all government officials were obliged to give reasons for their decisions. Okay, this was before the requirement was embedded in statute. So now with the Administrative Law Act, you can demand it. So this was an authority from before that, and what he had ruled was that an administrative body is also obliged to give reasons. And the High Court reversed his decision. It said that he said that they relied on a lot of international cases where what the position of the common law at the time was that they don't have to give reasons. And then he says, since then, basically everything has changed. Everywhere, with the introduction of the human rights things, and you know, it's in the statute that the decision maker has to consider the effect on the person's human rights. So they have to give explanation about that. So all the things that they keep saying about the Royal Commission stuff, that's bullshit. Because it's enforced through human rights.
Yeah, you know that he was a major proponent of human rights because he was, I think, the first openly gay High Court judge.
I don't know that. No.
No, he was, yeah.
No, but he's like what he did was just what in one of his judgments he basically said that all this debate about whether or not abuse of process is a discretionary criteria distracts from the consideration that it'll stop being a court of law if it looks the other way when it knows that there's abuse or there's the possibility of abuse. He says I couldn't think of any legitimate judge. So he says it cannot be a discretionary criteria just based on that, because if there is a possibility of abuse of process and the judge doesn't do anything, then they stop being a legitimate judge. So I think you will like the test that I've proposed. So do you understand the good thing about my test is that it redistributes the balance of power?
Yeah, no, I'm following what you're saying. It's just not a decision that's totally left. There are criteria that you can put in as opposed to for determining the
So the test is this. If a litigant makes or characterizes something that the judge has done in the most aggressively critical way that they can, and they don't get charged with contempt, then if what they're saying brings the administration of justice into disrepute or implies corruption on the part of the judge, then the judge must recuse themselves.
Yeah.
So the good thing about this is that there is a equilibrium between the judge and the litigant, because the judge can charge the person with contempt, but if they charge them with contempt, then they lose the power to have any, to regulate their affairs. The only problem with what I'm suggesting is that it would involve a lot of people cursing at judges, which is, not something that anybody's going to encourage.
No.
But it's like a hypothetical model, you don't actually have to curse. But the test is this: if the worst way in which the conduct is characterized, honesty. When I say worse than honesty, what I mean is that you can have someone who says, lying should be punished by death because that's what the principles are. But so long as they don't say that the judge lied 10 times when they had lied 8 times, it doesn't matter whether they think, lying is this or that. The point is that if the conduct is honestly characterized, only some kinds of mistakes will be corrupt mistakes. Do you know what I'm saying?
Yeah.
Because corruption implies that you're deliberately breaking the law to gain an improper benefit or to inflict an improper harm. So it's a twofold test. That one, you're deliberately breaking the law. 2, you're doing it to gain an advantage or inflict a disadvantage. So basically, only if you can imply corruption against a judge, honestly, based on what they've done. Like, we can do that against Downs now. Do you know what I'm saying? Sorry?
Yes, I hear what you're saying.
Because what she did was fraud. She deliberately left out the fact that I had written to her and said that we want an extension of time. She said we never wrote back to her about the orders that she was seeking. And this is the final thing I'm going to say. You read the Judiciary Act, right?
Yeah.
I mean, the 78B that I sent you.
Yes.
It literally says that it is the duty of the court to allow the Attorney General a reasonable opportunity to respond if a matter of constitution. So it's her duty. Now, I had sent her a partial copy of the constitutional notice, or Lulu had, the day before. So she knew we were going to lodge the constitutional notice. And I mean, I told her during the hearing as well that she's obliged to wait once the constitutional notice is filed. And then, do you know, later it says, the constitutional notice thing, that the Attorney General will reimburse or compensate any party that is inconvenienced because of an adjournment. I mean, that's the extent to which it goes, that section. That basically the matter has to be adjourned, and the Attorney General will compensate any party for any inconvenience that arises because of the adjournment. She didn't have a choice there, and then she's basically, do you know what I'm saying?
Yeah, she's gone to this matter.
So,
Constitutional matter.
and I mean, she understood what my argument was about the subpoena, right?
Yeah.
So, and this is another problem that she has, right? The party in the proceeding doesn't have a right to object to a subpoena. That's an accepted law. Even, what's his name? The magistrate, McKenna, ruled that, right?
Yeah.
So it's only for the judge. We have a right to issue a subpoena. No one can stop us. And the only thing that is relevant is whether we are trying to get something that is completely irrelevant.
Yes.
So I don't know why or how she could list the matter preemptively on that basis without the subpoena thing.
Yeah, that's a good point. I agree with that.
And she knew what the matter was anyway. So, so what I'm going to do is we're going to put all of this in an affidavit and exhibit the emails, and Lulu's going to do the affidavit. You know, because if I do it, then they're going to use that, the fact that I'm aggressive as the sort of excuse. So basically, you know, she'll say that in our like our position is that she's acted fraudulently, or that it can be said that we'll present my model and say that this is what I'm alleging, and you two can see the sense in what I'm saying, you know, conceptually. Although, you know, like, you wouldn't naturally have said that, but anyway, everybody agrees that what she's doing is extremely improper. And I'm gonna put the recording of our discussion on TurboScribe, and you can have a look at it. But I think we should put it in because it shows right after the hearing. Yeah, and you know, have a look through it. I think it's you know, sort of the image that you would be comfortable with anyway. But what we have to show is that, and then the way in which it will be presented is that this was your position, and also Lulu's position before she had given reasons. And you know, like me with all my you know, tools, I knew that if I could push her to give reasons, more things will come out. So I got you guys to agree with the thing, and then after reading her reasons, I have pointed these things out, and you guys see the logic of what I'm saying. Do you know what I'm saying?
Yeah.
So I think we do that, and it will definitely. And one other thing is relevant here, just so you know. The way I knew that she was being defensive about them was that during the hearing, I said that. So you know how she said the applications have not been lodged and blah blah blah. So she was going to use technicalities to get around the stuff.
Yeah.
She had already reasoned in her head how she was going to go about that. So she was completely fucking blindsided when I came up with a technical argument that if it's not filed, it's an irregularity. And then I pointed out that because it had been shared with the registry, it had been filed technically. So after the hearing, the chambers wrote and they said that sharing emails with her or with the chambers does not constitute lodgement. It was such a fucking defensive thing to say. Do you know what I'm saying? And then I clarified to them that, well, firstly, I'm not taking any position about what she's saying, except that I acknowledge that that is what her ruling is effectively, what directions are. But I wasn't talking about that lodgement. The thing is, with all of the emails, there's an automatic email for the registry that's copied in. And because it's included, that under the rules constitutes lodgement. And then I cited the rule to her. So, and the irony is that she's the presiding member of the committee that's responsible for the maintenance of the rules of Australian and New Zealand courts. So, it's just really silly. So, but she was being very fucking defensive about it. And that was the first thing she said. The second thing she said is that she's not going to have a look at any, she doesn't read emails or something like that. And then the third thing she said was that, what's the thing? That we better not have recorded the fucking hearing. Which, yeah. So I think it's not a good sign that the whole set of reasons was defensive, and I think we just need to put her on the thing. I'm not sure whether she's gonna actually recuse herself, but I think if we publish the stuff about Gorton and it gains traction over the weekend, then I can't see why she would want to stay in the thing, because she will know what the modus operandi is here, and that, I mean, the only way she can then not get in trouble later on is if she rules everything according to the law or within the margin of error. Do you know what I'm saying?
Yeah.
We don't have a problem with that anyway. So the only way it creates a problem for her, all the stuff that we've already documented, is if she tries to cover for them in the future. But that's what we want effectively. So I'm not so much opposed to her completely, but I mean, there's one of two things. Either she's decided that she wants to just try and avoid all the problematic determinations here, which is a problem because of two reasons. One, we have a right and she's not respecting that. But two, it means that she sees that we're being prosecuted for malicious reasons, and they're trying to bankrupt us, and she's not offended by that. Do you know what I'm saying?
No, I follow what you're saying. She should be
Outraged about. She should be outraged about that. Like it's an abuse of the court process, and then she's asking whether the contempt application should be an interlocutory application, which the law says it is. And can I say, I'm sure she's going to be worried about her reputation, because her father was not a former prime minister, and once we start publishing the stuff, I mean, we don't publish without any substance to it anyway, and when we publish the substantive stuff, it's gonna hurt her chances of progressing. Do you know what I'm saying?
Potentially.
No, I mean I don't think Gorton will come out of this unscathed, Peter.
Oh, no, you're probably referring to her.
Yeah, but I'm saying if she maintains her what she's done so far is not going to do anything. I accept that. But if she maintains her, like, I think she has met the criteria for recusal very easily because it's a very low bar. It's one reasonable person thinking. And by the way I framed the test is a more conclusive formulation. So because I can call her a fraud very safely based on what she has done, she's definitely been disqualified. So if she maintains her position in the proceeding and then tries to be, oppressive towards us, then it will basically lead to a similar thing as it did with Gorton. Do you know what I'm saying?
Yes, I understand. Potentially, right?
So I'm sure she's going to be concerned about that. So anyway, I'm going to let you go. So I'll get this stuff sorted. What's going on with your friend Simon?
Yeah, no, Simon rang me just while you were talking.
Okay, and I was working on the transcript, so I haven't written to the federal court yet, but I will write to them today, and let's see what they say then about the application. Yeah?
Yeah, cool.
All right, cheers, bye.